Hello again, everyone. I'm attorney Robert Flessas. Today, I'm going to show you an actual complaint or a lawsuit filed by Midland Funding against somebody here in Wisconsin. Now, the complaint I'm going to show you has been redacted. I took the case number out and I took out the defendant's name. But keep in mind that lawsuits are a public record. You can go to any clerk of court's office and you can get a copy of an actual lawsuit. But in case you're being sued by Midland or you expect to be sued by Midland, this video is going to go through it just to show you how they plead their case. I want to thank you for watching this video, and let's get started. First, they have what's called the caption. They're showing Midland Funding as the plaintiff, and they show the defendant. Here it would be your name and address. Next, they get right into what they're alleging. They're saying, one, that the original creditor was Barclays Bank Delaware, Juniper, and they entered into an agreement with the defendant to allow them to have credit that they used. Next, they're going to say that Midland now is in the business of purchasing debt, and they became, by that purchase, the successor in interest. What that means is they step now into the shoes of Barclays Bank, and they have all the right, title, and interest to sue the defendant because they own the debt. Next, they're saying that they're entitled to that money. Then they go into their three causes of action. All right. The first one is breach of contract. Everybody knows what that is. All right. They're saying that a contract was entered into by two parties, the plaintiff, or not the plaintiff, but Barclays Bank and the defendant. And the defendant didn't hold up their end of the bargain, which was paying them for the credit that they obtained. So therefore, they breached the contract. The second cause of action is saying that the account was stated, meaning that Barclays Bank sent statements to the defendant saying, here, you owe us this money now, make your payment. And the defendant refused to pay. And they didn't, more importantly, object to the debt. The third cause of action is unjust enrichment. What that means is by the defendant getting that credit and buying things on credit, that they were unjustly enriched, that they used that money to enrich themselves through their credit, and then Barclays Bank was burned. Next, they show what the damages are, and then they go into their final portion of their allegations saying that Midland has attempted to collect the debt either through letters or calling the defendant, and the defendant now refuses to pay. So what they've done is they attached as evidence a statement that was formerly from Barclays showing a billing date, when the payment was due, and how much is due. All right, now let me tell you this. There's two things that you need to do if you get sued and you receive a complaint like this. One, your jurisdiction may require you to file a written answer. Or if they don't require you to file a written answer, then they require you to come into court on the date that's specified on the complaint. That would be on the summons. If you do neither, what happens is Midland gets a default judgment against you. It's a slam dunk. Now they have the right to garnish you. And you can't go back into court and say, oh, you didn't know anything about this. So there's nothing you can do. It's too late. The next video, I'm going to go through the complaint and tell you how you can act on this, how you can defend yourself, and the things that you should do if you want to challenge it. Well, I'm attorney Robert Flessas. Thanks for watching, and we'll see you in the next video.